For today's story, we're covering an abuse case where a kid was forcibly removed from school and excess force might have been used. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn your subscription. For today's story, we're covering an abuse case where a kid was forcibly removed from school and excess force might have been used. This is the case of EW versus Detroit. In this case, EW was trying to get back into school in order to gain some property back of his own, but he was removed from the school using excess force, and now he's suing. So we're going to discover whether or not he can sue. So let's get started with this. On October the 9th of 2017, EW left his wallet with a teacher while he played basketball after school. After making it to the bus stop to go home, he realized that he forgot his wallet. He needed his money to make it home from school. EW walked back into school, attempting to retrieve his wallet from either the teacher or principal. He re-entered the school building from the side door and was confronted by Montgomery. EW alleges Montgomery yelled at him to leave. EW did not tell Montgomery that he was looking for his wallet. In his words, Montgomery was acting hostile and angry. EW left the building on Montgomery's command, but he re-entered from the rear. Montgomery met EW at the rear door. This portion of events was captured on camera, which is probably the only reason that we're in court at all. EW told Montgomery he needed to retrieve his wallet so he could go home. EW alleges that Montgomery did not listen to him, and instead told him to leave within 3 seconds and began counting down. On the video, an increasingly agitated FW is shown speaking to Montgomery. After some dialogue, Montgomery threw down a pile of papers he was holding and got in EW's face. When EW still did not leave, Montgomery grabbed EW and pushed him through the school doors. As the video shows, Montgomery pushed EW out of the building, pushing EW back on his heels through 2 sets of doors. Outdoors, EW contends, Montgomery slammed him to the pavement. Montgomery then held his knee on his chest for around 5 seconds. So, of course, this is the way that he tells the story, right? Because we're on a motion to dismiss. We're on a summary judgment, right? Because of qualified immunity. All right, so what matters is his telling of the tale. This may or may not be what actually happened, although some of it's caught on tape at least. So some of it seems to be well documented. But yeah, this is the story as he tells it, right? His wallet was there. He needed to get it in order to get back home. He couldn't get through the front door. When he tried to go to the side door, they pushed him out, tackling him to the pavement and causing some injuries. All right, let's read a little bit more. EW was picked up by his mother and taken to the emergency room. The contact between Wilkins' forearm and EW's face left him with a broken and dislocated jaw. EW testified that he also experienced severe pain in his shoulder that prevented him from raising his arm for several months following the incident. He also testified that he suffered psychological harm, including difficulty trusting police officers and men in general, bad dreams, trouble sleeping, and loss of dignity. So yeah, I mean, there was some damages here, right? There is a broken and dislocated jaw. That's pretty serious. And he had trouble raising his arm. So, you know, there's some fairly serious notable injury from this incident. Both Montgomery and Wilkins appealed denial of qualified immunity. So the district court said no, not so much with the qualified immunity. Public officials like the defendants here are immune from liability unless the plaintiff establishes a violation of a constitutional right that is clearly established. Yes, we know this standard all too well, so let's figure out if that applies here. The factors to be concluded as to whether the police officer used excess force are the following. If the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officer or others, and whether he's actively resisting arrest or attempting to evade arrest by flight. We have held these standards govern the use of force by a police officer in a school setting as well as generally. Taking into facts the light most favorable to EW as we must at this stage of the proceeding, all these factors suggest that Wilkins' use of force against EW was unreasonable. Wilkins had witnessed EW twice violate a school rule regarding which doors to enter. He did not suspect EW of any crime. The first factor thus cuts against a finding of use of force because there's no probable cause that EW had committed any crime at all. Second, on EW's version of facts, he posed no threat to Wilkins or others. There were multiple security officers present, and Wilkins was an adult man significantly larger than EW. Wilkins himself testified that he never saw EW threaten or strike Montgomery. Neither was EW nor Wilkins' version of events suggest that EW took any action to indicate he wanted to strike or threaten Wilkins. Thus, on this version of facts, he posed no threat. Taken together on EW's version of facts, Wilkins's use of force was unreasonable in violation of the Fourth Amendment. EW's right to be free from such violence was also clearly established at the time of the actions. A defendant is entitled to qualified immunity so long as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. On EW's facts, which again we're assuming for the purposes of this appeal, or this interlocutory appeal we should say, he was not resisting or indeed under arrest, did not pose a threat to Wilkins or anyone else, and was not suspected of a crime when Wilkins swung at EW and broke his jaw. Thus, a reasonable officer would have been on notice he was violating the Fourth Amendment. Wilkins urges us to weigh the facts differently. He asks to consider EW's purported verbal resistance as a sort of active resistance to arrest that must justify the use of force. That seems quite a contention. A little verbal resistance is warranting of force. Okay. He also quibbles with the district court's characterization of a straight arm forearm strike as a punch, which I guess they're technically different, but your version sounds worse, and disputes the accusation that he swung at FW. But this account is disputed by FW's version of the facts, and we must view these facts in the light most favorable to EW at this stage because we're in interlocutory appeal. The factual disputes are for a jury to resolve, not for us. So yeah, as always, this is something that has to go to trial. But the question is, on FW's version of facts, can you get to the cop? And the question answer is yes. Okay, so that gets us as to the police officer. But then, of course, there's the question about the other school official, who's not a police officer. How about his liability for participation in this? Okay, so we have to go through the analysis for the school official. So let's do that. EW also claims that Montgomery's use of force violated the clearly established right. The district court determined that the facts precluded summary judgment as to this aspect, and we agree. We have held the 14th Amendment due process right provides public school students with the right to be free of state intrusions into the realm of personal privacy and bodily security through means so brutal, demeaning, and harmful as to literally shock the conscience. In evaluating the claims the teacher or school administrator acted outside of that right, we applied a test asking for the following questions. Was there a pedagogical, that is to say, an educational reason for the use of force? Was the force utilized excessive to meet the legitimate active in this situation? Was the force applied in a good faith effort to maintain or restore discipline, or maliciously and sadistically for the very purpose of causing harm? And was there a serious injury? In this case, material questions of fact preclude summary judgment as to each question. A reasonable jury could conclude that Montgomery had little educational reason for his actions. Montgomery himself stated that he sought to restrain EW and remove him from the school building because he was there illegally. A reasonable jury could also conclude that Montgomery did not act in good faith. In addition to alleging throwing EW to the ground and pressing his knee into his chest, EW testified that Montgomery was angry and hostile. A jury could conclude that Montgomery acted principally out of anger and malice rather than through any good faith desire to secure the school building. Finally, material questions of fact pervade as to serious injury. We've suggested that a claim of malicious force by a school administrator delivered without educational purpose can survive summary judgment without showing of injury, but of course, they have put forward evidence of injury, including evidence of injury to his shoulders that are potentially attributable to Montgomery. EW has also shown evidence of a lasting psychological harm that a reasonable jury could find constitutes a serious injury. Thus, that brings us to the end of the case of EW versus Detroit. In this case, EW was trying to get back into school and, not so much with that, having some problems. But the school lost at the district court level and the Court of Appeals agrees, at least on the summary judgment standard. There's enough here to say that the people did the wrong thing and used excessive force, given this injury. So we got all that, and he can go back to trial and try to determine what are the facts. And at least for a moment, that brings us to the end of consideration of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.